Now, in simple words, Parliament by law can change the composition of the Supreme Court. That is what you need to keep in mind. Suppose if there is a question that which of the following institutions or authorities have the right to change the strength of the Supreme Court or can alter the composition of the Supreme Court, keep this in mind, it is the Parliament of India. This is established by convention. Again, keep this in mind that there is no explicit provision in the Indian Constitution which testifies to this, but it is more by judicial convention, and this is how it happens in most of the countries. But whether this should be the criteria, seniority should be the criteria, or meritocracy should be the criteria, that can be another debate. The judiciary. Now you know that India has an independent and integrated judiciary, and at the top of Indian judiciary stands the Supreme Court of India. The Supreme Court of India has succeeded the Federal Court, which was established under the Government of India Act 1935. But keep this in mind that the Federal Court was not the highest court of appeal under British India. In fact, it was the British Privy Council which was the highest court of appeal. So, Supreme Court has not only succeeded the Federal Court of India as the highest court or the apex court of the land, but it has also replaced the British Privy Council as the highest court of appeal. Now, let us have a look at the Supreme Court of India. In fact, Articles 124 to 147 in Part 5 of the Indian Constitution talks about the organization, independence, jurisdiction, powers, procedures and so on of the Supreme Court of India. Now you see that the Supreme Court of India was inaugurated on 28th of January 1950. Now some of the provisions of the Indian Constitution which came immediately into effect, one of them was were those provisions that related to the Supreme Court of India. Now, it succeeded the Federal Court of India established under the Government of India Act 1935. Why we are calling it a Federal Court of India? Federal Court of India, why? Because the Government of India Act established the federation in India. Although the federation did not take shape in the way as the Act has envisaged. But that is altogether a different debate, so I am not moving into it. But anyhow, the Supreme Court has replaced the British Privy Council as the highest court of appeal. That is the second thing, important thing that you need to keep in mind. So first, it has succeeded the Federal Court of India and it has replaced the British Privy Council as the highest court of appeal in the land. So the Supreme Court is not only the apex court, but it is also the highest court of appeal. The Supreme Court is also the constitutional court of the land because it is the final interpreter of the Indian Constitution. In fact, all laws are also tested by the Supreme Court, and in fact, the validity of the laws or legislations are tested against the provisions of the Constitution. Only when you find resonance between the laws and the provisions of the Constitution, the laws are declared as valid. Otherwise, they are declared as unconstitutional and void. Let us now have a look at the composition of Supreme Court. Originally, the Supreme Court consisted of 8 judges, 1 Chief Justice and 7 other judges. But successively, Parliament by law have altered the total strength of the Supreme Court, and at present, it consists of 34 judges, 1 Chief Justice of India and 33 other judges. In fact, this was done very recently in 2019. Before that, the total strength was 31. 1 Chief Justice and 30 other judges. Let's have a look at it. So I'm saying originally the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges. The Parliament has increased this number of judges progressively. It means through several over the years you will see that this strength has been modified successively. At present, the Supreme Court consists of 34 judges, 1 Chief Justice and 33 other judges. This is what you need to keep in mind. In 2019, the Centre notified an increase in the number of Supreme Court judges from 31 to 34. It means initially or previously rather it was 31 judges. It means 1 Chief Justice of India and 30 other judges, but now it is 34. It means 1 Chief Justice of India and 33 other judges, including the Chief Justice of India. This followed the enactment of the Supreme Court Number of Judges Amendment Act 2019. Now, in simple words, Parliament by law can change the composition of the Supreme Court. That is what you need to keep in mind. Suppose if there is a question that which of the following institutions or authorities have the right to change the strength of the Supreme Court or can alter the composition of the Supreme Court, keep this in mind, it is the Parliament of India. Clear? Let's have a look now at the appointment of judges. Now there is a lot of controversy regarding the appointment of judges. We'll deal with all of that, but let's have a look at the constitutional provision first. It says the judges of the Supreme Court are appointed by the President. It means all the judges, including the Chief Justice of India, are appointed by the President of India. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. Now, this is what the Constitution explicitly says. It says that whenever the President will appoint the Chief Justice of India, he will consult, apart from his Council of Ministry, he will also consult such other judges of the Supreme Court and High Court as he may consider necessary for the appointment of the Chief Justice of India. And while appointing any other judge, apart from the Chief Justice, he must consult the Chief Justice of India also, along with the other consultations. So, he's saying the other judges are appointed by the President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Court as he deems necessary. The consultation with the Chief Justice is obligatory in case of appointment of a judge other than the Chief Justice. Now, you see that initially, if you look at the constitutional provision, prima facie, it gives you an impression that all the power regarding the appointment of judge of Supreme Court, including the Chief Justice of India, rests with the executive. But you know that in the successive judges cases, which are known as the first judge case, second judge case, third judge case, etc., the Supreme Court has altered the meaning of this word consultation. In fact, in the first judge's case, Supreme Court said that consultation doesn't mean concurrence of opinion. It just means exchange of views. Whereas in the second judge's case, the Supreme Court altered this view and said that concurrence means consultation, and thus evolved the institution of collegium. Now, the collegium system has maintained the independence of judiciary, which is a part of the basic structure of the Indian Constitution. Let's have a look at the controversy over the appointment of the judges. In the first judge's case, which was in 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. It means the Constitution is very clear. It says that when the President will appoint the Chief Justice of India, he will consult such other judges of the Supreme Court or the High Court as he may consider necessary. And when he is appointing any other judge of the Supreme Court, along with this consultation, he must also consult the Chief Justice of India. In this case, consultation with Chief Justice of India is obligatory, but there is nowhere written in the Constitution that such consultation and the opinion that is tendered by the Chief Justice of India is binding upon the President. That has been done by judicial interpretation of the provision. So, in the first judge's case in 1982, the Supreme Court said that consultation does not mean concurrence, it just means exchange of views. However, in the second judge's case, which was in 1993, and this is perhaps the most popular one, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that advice tendered by the Chief Justice of India is binding on the President. This was proclaimed by the Apex Court in 1993 in the second judge's case in matters of appointment of the judges of the Supreme Court. But the Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. So here, the second judge's case made a new interpretation. It said that the President will consult the Chief Justice of India, and the Chief Justice of India, before tendering his opinion to the President, which is now binding on the President, must consult two senior-most colleagues of him. Now, similarly, the third judge's case in 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality of judges. Plurality of judges means it is not the sole opinion of the Chief Justice of India, rather it is the collective opinion of the collegium, and thus evolved the collegium institution in India further. Now you see, what does it mean? It means the sole opinion of the Chief Justice of India does not constitute the consultation process. It says that the President must consult the Chief Justice of India. So, sole opinion of Chief Justice of India does not constitute the consultation process. In fact, if the Chief Justice of India gives his opinion to the President without consulting his brethren judges, then such an opinion shall not be binding upon the President of India. It is only when it is tendered after due consultation with the collegium and it constitutes plurality of opinion. I hope you got it. Now, he should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, it means in the 4-member collegium, if 2 of them at least say no, the Chief Justice of India cannot forward that consultation to the President of India. He should not send the recommendation to the government. It means the President of India. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. So keep this in mind. The advice which is tendered by the Chief Justice of India is now binding on the President, but the Chief Justice of India can tender his advice only after consulting the collegium of 4 judges, and if suppose 2 of them say no to a particular recommendation, the Chief Justice of India cannot forward it to the President. But once forwarded, after following the due process of the collegium, it is binding on the President of India. So this is a peculiar case in India where the judges appoint themselves, and because you know that there is independence of the judiciary, and independence of the judiciary is part of the basic structure of the Indian Constitution, the collegium system persists in India. In fact, the 99th Constitutional Amendment Act, it sought to replace all of that by a new institution called the National Judicial Appointments Commission, and we need not go into the details of its structure. Why? Because that body has been abolished and it has been declared as unconstitutional and void, because Supreme Court declared the 99th Constitutional Amendment Act as unconstitutional. Why? Because it breached the basic structure of the Indian Constitution, because it hurted the independence of the judiciary. So the National Judicial Appointments Commission, which was created in 2014, notified 2015, lapsed in 2015 because the act itself was declared as unconstitutional. So it no longer exists, and collegium system still persists because independence of the judiciary is a part of the basic structure. Let's see how the Chief Justice would be appointed. Is there any convention in appointment of Chief Justice? Yes, there was. Since the commencement of the Constitution till 1973, you will see that this was followed, that the senior most judge of the Supreme Court would be appointed as the Chief Justice of India. But then Justice Ajit Nath Ray, or A.N. Ray, was appointed as the Chief Justice of India, superseding 3 senior most judges. In 1977 again, Justice M.U. Beg was appointed as the Chief Justice of India, superseding senior most judge, and thus it was made clear by the Supreme Court that as a rule it is binding on the President to appoint the senior most judge as the Chief Justice of India. So now the practice which existed prior to 1973 has been restored. So let's have a look at this. From 1950 to 1973, the practice has been to appoint the senior most judge of the Supreme Court as the Chief Justice of India. This established convention was violated in 1970. This is a convention. Keep this in mind. There is nothing written like that in the Constitution. Was violated in 1973 when Justice A.N. Ray was appointed as the Chief Justice of India by superseding 3 senior judges. In fact, these 3 senior judges resigned as a mark of protest of what had already happened. It happened during the time of Indira Gandhi government. Again in 1977, Justice M.U. Beg was appointed as the Chief Justice of India by superseding the then senior most judge. This discretion of the government was curtailed by the Supreme Court in the second judge's case, which was 1993 case, in which the Supreme Court ruled that the senior most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Now this is established by convention. Again, keep this in mind that there is no explicit provision in the Indian Constitution which testifies to this, but it is more by judicial convention, and this is how it happens in most of the countries. But whether this should be the criteria, seniority should be the criteria, or meritocracy should be the criteria, that can be another debate. In fact, seniority is often attained due to meritocracy. So there is a nexus also between the two. Let us have a look at the qualification of the judges. The necessary qualification that a person requires to be appointed as a judge of the Supreme Court. A person to be appointed as a judge of the Supreme Court shall have the following qualifications. What are they? He should be a citizen of India. Again, you see that non-citizens are not allowed to sit as judges in the Supreme Court or in the High Courts. Second, it has 3 more conditions you can understand. He should have been a judge of a High Court or High Courts in succession for 5 years. It means that person should have acted as a judge in one High Court or in more than one High Courts in succession, and if you collect all those years, it must be at least 5 years. That for at least 5 years he has acted as a judge in one High Court or in more than one High Court. But you know that the time period is at least 5 years. Second, he should have been an advocate of a High Court or High Courts in succession for 10 years, or if he has not acted as a judge, he should have acted as a advocate. It means he must have pleaded before a high court, one high court or more than one high court, for at least 10 years in succession, or he should be a distinguished jurist in the opinion of the president. A distinguished jurist is one who has extraordinary knowledge of law and jurisprudence. That is a distinguished jurist. So, if any of the three conditions satisfy and he is a citizen of India, then he can be appointed as the judge of the Supreme Court. But you know how is the appointment process? All by the collegium, and the consultation is now concurrence and is binding on the president. Now, from this above conditions, we understand that the Constitution has not specified any minimum age that a person should attain for appointment as a judge in the Supreme Court. Like, remember, if you want to go into the legislature, if you want to be a member of the Rajya Sabha, you must attain at least 30 years of age. For Lok Sabha, at least 25 years of age. Similarly, age restrictions are there with respect to, or rather age eligibility criteria is there with respect to the President's office and the Vice President's office as well. But as far as the Supreme Court is concerned, there is no such minimum age qualification. Let's have a look at this. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment of judge of the Supreme Court. So that is what you need to keep in mind. Now, the judges also take an oath. And what is the oath? Let's have a look at this. A person appointed as judge of the Supreme Court before entering upon his office has to make an oath and subscribe an oath or affirmation before the President or some person appointed by him for this purpose. In his oath, a judge of the Supreme Court swears, and what does he say? To bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India. These two lines are almost common in most of the oaths. To duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear of favor, affection or ill will. It means it highlights his impartiality and non-partisanship in matters of adjudication, and to uphold the Constitution and the laws. In fact, you see that in these 4 lines, perhaps the entire expected character of the judge is encompassed. Anyhow, the salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. And you also remember that the salaries of the judges and the allowances and the pensions of the judges of the Supreme Court are charged expenditure on the Consolidated Fund of India. Remember from our yesterday's class that we talked about the charged expenditure and expenditure made from the Consolidated Fund of India? So there is a distinction between the two. The former is non-votable, whereas the latter one is votable. Let us have a look at the tenure of the judges. The Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following 3 provisions in this regard. It means there is no fixed tenure like 5 years, 10 years, no such tenure. But 3 conditions have been laid down. And what are they? He holds office until he attains the age of 65 years. So if you are appointed at 63, it's only 2 years tenure. If you are appointed at 40, then maybe you have 25 years tenure. So there is nothing like that. Any question regarding his age is to be determined by such authority and in such manner as may be provided by Parliament and not by the President. So keep this in mind. He can resign his office by writing to the President because he is appointed by the President, so he is resigning by addressing the President. He can be removed from his office by the President on the recommendation of the Parliament. This you can understand as the address made by the Parliament. The removal process of the judges of the Supreme Court and High Court is also known as the impeachment process. But this is a legal term and not a constitutional term. The term impeachment in the Constitution has been used only with respect to the President of India, and the ground is violation of the Constitution. Whereas for judges, the grounds are 2: proved misbehavior or incapacity.